Everyone, we were assigned the Supreme Court case, the United States versus Cruikshank. This is a case from 1875, which takes us back in time very, very long ways. So what I'm gonna ask us to all do right now is just sort of hit rewind. Everybody just forget for a second that you are in the year 2024. We're leaving the year 2024. There's nothing on the screen that you should be looking at. Everybody should be in rewind mode right now. And everybody should be taking that journey now all the way back to 1865. We are no longer in 2024. We're now in 1865. I'm listening for someone to tell me which historical era we happen to be in. I'm listening.
Reconstruction.
So we have just left out of the chattel slavery era, and now we are in the Reconstruction era. And there's some very important pieces of legislation that comes out of this era. I'm listening for somebody to tell me about just one. I want to know what piece of legislation it is, and I want to know what it accomplishes. I'm listening. There's some very significant pieces of legislation. I'm listening.
The 13th Amendment.
I agree.
Which is the amendment that attempts to get rid of slavery. Well, it says it gets rid of slavery, but we know we have some remnants of slavery happening, but it leaves open, except for prisoners and things.
So ultimately, the way that we're going to end chattel slavery is not through this thing called Emancipation Proclamation. So if you were taught that, you know that is false. That really was just a military order in order to get bodies out on the battlefield, but that didn't end the system of chattel slavery. It took us this piece of legislation called the 13th Amendment, and what that attempts to do is end this institution of chattel slavery. There's two other pieces of legislation that comes out of this era, happens to be very important for purposes of this case discussion. I'm listening. Yes?
The 14th Amendment,
Which accomplishes?
amongst other things, it establishes equal protection under the law.
So this is the way we say to all of these individuals that have been pieces of property since 1619, we're no longer going to treat you as some innate object. You actually have personhood. You actually have citizenship. You actually now have all the protections of the United States Constitution. So we give you due process through the 14th Amendment. We give you equal protection through the 14th Amendment. We call you citizen now through the 14th Amendment. And we say that you have all the privileges and immunities of citizenship. This is very radical stuff. I mean, think about this in 1863, 1862, you were pieces of property. Now I'm calling you a free person. I'm actually elevating you to something bigger than free person. Now you are actually a citizen. What is the other piece of legislation? I'm listening, sir.
Well, it was the. It was the 15th Amendment, which established to these now free men after the abolishing of the chattel slavery system and the extending of the protection to them, it gave them the power to vote.
So this is very important. What he says is that we, through the 13th Amendment, give you this thing called physical freedom. Like you can literally walk around, you can get employment now wherever you want, but physical freedom does not do us any good if we don't have any negotiating power, right? And so the 14th Amendment starts to give us that, because now you owe me due process. You can't lynch me anymore because that's not due process. You owe me a process. And then the 15th Amendment does something many people just completely overlook. And don't leave here today not understanding there's something radically different between physical power and political power. The 15th Amendment is an equalizer. It now says that I am not just physically equal, not just socially equal, but I get to sit in a jury box, political power. And when I sit in the jury box, I'm good enough now to decide the rights of white men. Now I actually get to go cast a vote. And so now my vote gets to communicate the things that I feel my society should have. So this is a power unlike any of the other amendments, that 15th Amendment, because now this is about me being a part, not just physically, but being able to change structures, change systems, change all the laws that used to make me a piece of property. How about that? This is a big deal. This is a very big deal. And this left people unsettled. And so before we move on, everybody take a peek at the first screen, because I want us to leave this conversation. Everybody sees this. This basically solidified the conversation we just had. And you cannot understand Cruikshank until you understand this moment in time. You cannot read Cruikshank as if you live in 2024. You read Cruikshank as if you are in this moment experiencing this radical change in circumstances for all of these newly emancipated people. And so now we have this framework, and in each of these amendments that you see here, the federal government did something really, really interesting. They put some clauses in the 13th, in the 14th, in the 15th called enforcement clauses. Anybody have a guess why they would do something like that? Why would Congress, when they're drafting the 13th Amendment, put an enforcement clause? Why would they do that? Somebody talk to me, I'm listening.
Hold on. Good, Nathan? Right.
Because without the enforcement clauses, the states don't have a reason to actually follow the law.
That's exactly right. It's like today, why are y'all here? Tell me the truth, be honest. Why are y'all here?
Mandatory.
Friday.
Listen.
What did you say? The word mandatory. Did y'all hear that? That word mandatory. That word, you better be in your seat. That's why. So that's what the federal government was thinking. Like, what would happen if I would have said, I hope to see y'all Friday? And me and the camera crew in here, right? By ourselves. So that's what the federal government realized. Like, I can't think about this now. Don't look at this like this is 2024, because it's not. This is a people down south. They felt so invested in the way they were doing things that they were gonna rise up. They were actually gonna stand up to the whole United States government. This is not some people who just have a little subtle disagreement. This is the South telling the United States government that I am not going to do it your way. We got a way we do it down south. So we're so convicted about our beliefs, we're gonna start our own constitution. So the Confederates, it wasn't just a rogue organization, they were organized. They had a constitutional convention, they had officers, they had meetings, they had an agenda. So the federal government knew that if you're that organized, if your will is that strong, that you would go to war against your government, that I'm gonna separate. I'm not anymore involved with this state. I got my own state. They knew that if you were that determined, and we say, treat them nice, give them 13, 14, they're not gonna do it. So what you're looking at on the screen is in that 13th Amendment, everybody talks about Section 1. Everybody talks about Section 1. Nobody realizes there's a Section 2 that says Congress has power to enforce. Now, what are they gonna enforce? They're not just enforcing chattel slavery. They're enforcing anything that looks like, tastes like, smells like chattel slavery. And what is chattel slavery? It's a system where we deprive people of human dignity. It's a system where we deprive people of freedom of choice. It's a system of exploitation. And so any system like that is considered an incident and a badge of chattel slavery. So you would have seen Congress come in when we in the country used to have those zoning regulations that says, Black people, you can't live here. Remember that day under those restrictions? Do you know how we stopped those restrictions? Congress used Section 2 of the 13th Amendment. Do you see how that works? So the restrictions are not literal chattel slavery, but they're a badge and an incident. So the same thing happens with the 14th, same things happen with the 15th. Why? Because Congress knows that as soon as we leave the South, they're gonna go right back to doing what they were doing if we don't have an enforcement mechanism. This is extremely important for understanding Cruikshank because Cruikshank comes after this history, right? So now what we have here is Congress saying we don't trust the South. What is the South saying about Congress? It's mutual. It's mutual. I don't like you either. I don't like nothing about you, Congress. Now, has that gone away? Now, everybody in this room should be saying, I'm starting to see how this is really not an old case anymore, right? Because it's this tension never, ever ending between the South and Congress. And if you live down South, what's the famous 2 words that you hear? I'm scared to ask this question around this certain person on the front row. What's the famous question that we hear? I was having a conversation about speech and I said, y'all, what's the F word? No, I said the B word. The B word. What's the B word? And somebody on the front row, I'm not gonna identify the person, but they wanted to test the limits of free speech. And guess what? We got the real B word in con law. But here's, what is the 2 words that the South loves to say when it comes to the federal government trying to tell them what to do? What's the 2 words? Yes?
States' rights.
Oh my God, oh my God. He just redeemed himself. Okay. States' rights. Y'all heard that before? That is all tied to this history. So every time you hear Louisiana, Mississippi, Alabama say states' right, it goes to this conversation. It is the idea that as the federal government, we were doing what we thought we should be doing down South. And then you came in with these amendments and started trying to tell us what to do. We don't want that kind of federal government. We don't want that federal government that tells us what to do. We want to have states' rights. So every time you hear that, understand that that is the framework for this case. You know, a lot of times I've said this in class because I love blues music, and I've talked to you about, you know, in the blues songs, how all the men have a wife and then they got a side piece. So that's kind of the way I look at the federal government, right? So the state says to the federal government, you're my side piece. Now, what do you do with your side piece? Whatever you want, whenever you want, but not every day, right? So that's how we look at the federal government. I don't want you in my house every day because you're not my wife. You're my side piece. I only want you from 2 to 4 on Fridays because you're my side piece. That's how we feel about the federal government in the South. We don't want you in our homes, in our bedrooms, in every conversation we have. Just show up when we have a Hurricane Katrina. That's all we really want, right? That's all we want. Stay in your lane. And that's what this case is all about. And every time now in 2024, next 2030, when you hear this discussion of Congress, you don't have the power. We have the power. This is the foundation for that conversation. So now what I want to talk about is there's a lower court opinion. And remember, I said to you all that we for a long time didn't have the 3 tiers of courts that we know today. We didn't used to have that appellate system until the 80s. So this case won't have any appellate history. It goes from a district court in Louisiana up to the US Supreme Court. So when it's at the district court, though, something very interesting happens. On page 711 of the lower case, and I don't expect you to look that up, what the lower court says is, you know, when we think about these Reconstruction amendments and what they really wanted for the newly emancipated people, they said what we think they were doing was giving Congress the full effect to bestow liberty upon these people. Liberty is something way broader than freedom. And so if the idea was that Congress was to have the right to bestow liberty, Congress was going to give you something bigger than freedom. And so that is an important thing to start with. And here's an exam point that I want you to know. With each of these enforcement clauses that we just talked about, they're considered remedial legislation not being needed. And so this alone, which you see highlighted under 13th, 14th, and 15th, Congress doesn't need any remedial legislation in order to enforce. All they need is to have proof that it is a violation of the 13th, they can enforce. Proof that it's a violation of the 15th, they can enforce. They don't have to have some remedial legislation saying you have this power now, go and use it. And so the thing to understand is this stuff is very self-executing. You should be saying, okay, now that she says that, it makes so much sense to me when I read Cruikshank that there's this talk about the Reconstruction Amendments. Why? Because they're self-executing. Congress should be able to use them whenever they feel the need to correct some 13th or 14th or 15th Amendment violation. So everybody, when you read Cruikshank, should be saying, now that I understand these things are self-executing, why weren't they put to use in Cruikshank? Did y'all consider that? Okay, so we'll be talking about that. So now, this moment, what year are we in again with Cruikshank? 1870s, right? What are those newly emancipated people doing? Because they were freed in 1865, so we got a few years now under our belt of freedom. What are they doing? I mean, they had a limited array of options before the 70s, 1870s, but by now they've had some time to be free. What are they doing? Give me some sense of the things you might see Black folks doing. I'm listening.
Utilizing their political power to now hold public office.
So they are running for office. I mean, everybody in this room, like, you should be sitting here saying, unbelievable, unbelievable. I was captive in 1865, and in 1870, I'm actually running for a political office. That is unbelievable. What else are they doing? What else? Talk to me, somebody. What else? I'm listening.
Establishing their lives as free people.
So what does that mean?
Say that without the.
Establishing their lives as free people, so that would include building homes, communities, voting for their own community.
So they're trying to just get day-to-day normalcy, right? Get a house, get employment. I heard her say the word vote. They're trying to become active voters. Why are they voting? Why are they interested in voting? I mean, I don't have anything. I don't have a career. Why am I going to be worried about casting a vote? What is that about? Talk to me, somebody. I'm listening.
I would say to be able to change what's actually going on and the laws that have been in place that set them back. They would want to get their voice heard so that they can make new improvements.
Which says that they were somehow able to forgive the sins of this country. Did you hear what he said? Somehow they left that circumstance of chattel slavery and said, I have no anger toward this government. I want to be a part of that government. I want to hold an office in this government. I actually want to be a part of making laws that could improve this government. So there's something resilient about a people that could emerge from those circumstances. And their first thought is, I want to vote. I want to work in the system. I don't want to work against this system. And then they're getting educated. When do we get this great institution that we're sitting in today? When do we get this institution? Talk to me, somebody. And Google, how do we know? 1880. 1880 is when we get Southern University, the very place we're sitting at. So that tells you there was a need for people of color to be educated, and this institution was created just for that purpose, to educate people of color. What else are they doing? elections, they are voting, they are going to school, they're trying hard to be assimilated into this way of life. There's something else that they're trying to do that is very different from the freedoms they would have had in chattel slavery. What is it? Something we take for granted today, this generation. What is it? Somebody said it. Was it Garcia? Who said it? All right.
Being able to be in the jury.
Beautiful. Did you all hear that? That they're actually wanting to sit in and be a part of jury service. What is jury service? It's really just pronouncing your opinion about what is the boundary lines in society. They wanted to be a part of that. So you can see that the effort to integrate, the effort to leave chattel slavery and assume the role of citizen, they took it seriously. They truly, truly embraced it. But what happened to the South? Did the South like what they were doing?
No.
What did the South do? In response to them trying to be voters and jurors and hold public offices and get educated, what was the reaction to that? I'm listening.
They started enacting their own form of extrajudicial justice.
So the South says, we don't want that. We're not exactly welcoming of you into this social structure. We don't feel like we're equal. That was the South. If you take a look, I wanted you to see this. And Sadie, if you can use the pointer, there's a couple of things that I marked for you to point to. But if you take a look right above the image in the middle, right above that, right about right here, you're gonna see the words, 2 coal-black Negroes represented the state of Mississippi in the US Senate between 1870 and 1880. So you can see them, they're not just local representatives, but they're now in Congress at this point in time. You can also see that there's some representatives from Georgia, South Carolina, Alabama, and Florida. But I want you to look in the box where the 2 men are. There's a word, 2 words there. It said what is happening now because we're getting so much Black presence in Congress. They said this is now getting ready to be an attempt at Black supremacy. Do y'all see that? This is an ad from back in the 1870s. Go to the next page. Listen to this language. It says, due to the courageous efforts of aroused Southern whites and the old KKK, the South eventually wrestled political control away from the nigger and the carpetbaggers and ended the era of Black supremacy. They restored the majority rule of white supremacy, and we are committed to that end. In the middle photo, you see the caption saying, this is in 1872, our officials. This is the day of Cruikshank, and this gives you a visual of the things that people of color had already accomplished by the time we get to Cruikshank. Look at them, look how distinguished these men look, and they are now not just holding local office, but they're holding federal offices. They are in Congress, they're holding state offices. And there is now this fear that Black supremacy is taking over the South because they are doing all the stuff that the 13th, 14th, and 15th Amendment charges them to go out and do. And even now trying to get into other spaces. And so there is anger. There is great resistance. And then we get to this moment in time where we get Cruikshank. This is April 13th, 1873, and we're in Grant Parish, Louisiana. So this is local history. And we are told that at this moment, the group of defendants, Cruikshank being one, has about 100 other folks with Cruikshank that day. And we know from reading the Supreme Court opinion that they're assembled in this town in Grant Parish, Louisiana. And we know that something happens, and we know there's some indictments, correct? We know that count 1 of that indictment involves the right to peaceably assemble, which we've all learned about in Con Law 1, First Amendment protected right. We know count 2 involves the right to bear arms, yet another constitutional principle. 14th Amendment says you're a citizen. 14th Amendment says you have all the rights of the Constitution, yet there is this allegation now that the people of color, and there's nothing on the screen right now, but the people of color are not able to assemble. They're not able to bear arms. Now, count 4, there's a conspiracy to deprive them of their equal protection. Count 3, we're depriving them of their due process. Count 6, we're depriving them of their right to vote. And so we get this trial. The trial happens in New Orleans. In that courtroom in New Orleans, some are found guilty. And then they ultimately file a motion for a new trial. What is the position here of this group of defendants? Cruikshank and these other 100 folks, when they go up to the Supreme Court of the United States, and they meet Chief Justice Waite. He is writing the opinion we read. What is their entire issue? The question that they're asking the Supreme Court of the United States to answer. What's the issue? What do they want the court to answer? In other words, yes, why are they at the Supreme Court of the United States? All the way in the back row?
I think they're asking, can the federal government prosecute the citizens based on their conduct and their acts with them, their right to assemble?
Perfect. So they're really saying states' rights. They're really saying, Congress, do you even have the power when these 100 people in Grant Parish, Louisiana, get into a little tuffle with some other folks in Grant Parish, Louisiana? Does the whole federal government show up? That's the question they're asking. Does Congress really have that kind of power? We know you have power because we just saw those 13th, 14th, 15th amendments, and they have enforcement clauses in them. And we also know you have power because you drafted a piece of legislation called the Civil Rights Act, which is an enforcement clause as well. But do you really have power to come and do that when it's just some folks in Louisiana? I mean, this is not Louisiana, Texas, Mississippi folks throwing down somewhere on a highway that's owned by the federal government. This is in Grant Parish, Louisiana. Now, that's a very important question. Do you all agree? Because if the question is answered wrong and we say, Congress, you have that power, what's going to be the consequence for the folks in states like Louisiana and everywhere else? If we tell Congress, you can come down every time you smell a violation of one of those amendments, what's going to happen? They're always here. There is no separation between state and federal. There is no, the states feeling somehow that they're being smothered, that they're being bullied, that they're being micromanaged. And so the question is very important because we have to come up with this idea of balancing the powers of Congress. And this might be easy, but there's a reason why it's difficult. And it's difficult because at this hour, Congress legislated another federal law. In addition to all those three we just talked about, we have the Civil Rights Act of 1870. That Civil Rights Act of 1870, we call it the Klan Act. Why? Because the Klan inspired it. And so it gives Congress the ability to come down when there's Klan activity and get involved to try to stop it. Now, I want to talk to you about the page 540 from the opinion. Don't go get it. I'm going to read it. But I'm going to ask somebody in this room to tell me, after I read you 4 or 5 lines, there is one word that every student in law should be able to tell me. Those 4 to 5 lines, if I had to reduce it to one word, the word is. And so this is what the opinion, Cruikshank, says to us as it tries to discuss whether Congress has this power or whether Congress is taking power it really shouldn't be taking. The court says, and I'm quoting, "We have in our political system of government of the United States a government of the several states." That is line 1. It goes on to say each one of these governments is distinct from the other. Each has citizens of its own. Each has its own allegiance, its own rights, and within its jurisdiction, the need to protect those. It goes on to say the same person may be at the same time a citizen of the United States as well as a citizen of the state. But his rights of citizenship under one of these governments will be different from those under the other. Now, it goes on, one more line, two more lines. The people of the US are subject to two governments, one state and the other national. But there is a need to be sure there is a conflict between the two. The powers which one possesses, the other does not. They are established for different purposes and they have different jurisdictions. All of that, brilliant law students, reduced to one word, is what? Is what?
I was gonna say federalism.
Thank you. It is federalism. And thank you for not having me say it is the F word. Thank you. It is federalism. All right, great. So all this is about federalism. Everybody remember that from Con Law 1? That's what we're doing here, trying to figure out those boundary lines. How do we divide power to make sure there is sufficient power so we don't go back to the days of the Articles of Incorporation, but not too much power where we have a king. And so now we gave a lot of discussion in the lower court opinion. Judge Bradley is writing to how do we decide this argument, and Judge Bradley frames this beautifully. He starts off just like you should have learned in Con Law 1 and says Congress can act in two instances. One, if the Constitution gives them an express grant of power. Y'all remember that? And then the second one is they can say through the necessary and proper clause, we get to do it. Remember that? So that's how Bradley frames this. And he says, but listen, Bradley tells us that there is something different about power to enforce versus a method of enforcement. So is Congress really trying to figure out a method of enforcement, or is Congress using power to enforce? Bradley makes a really big difference between them, but Bradley goes on to say, really, I think the line here that we need to watch is how big of a right is at issue. So if it's a big right, like a fundamental right, Bradley says maybe it is time to allow Congress to step in. But if it's a baby right, maybe we'll let the states handle it. So that's sort of his framework. And he uses another example. He says, listen, some of the amendments really create an affirmative duty. They say the state, you need to do this. And then some of the amendments don't create any duties, like the 15th Amendment, for example, it doesn't create any duties. It doesn't tell the states that you have to let these people vote. All it says is that you can't deprive them of the vote, right? That's all the 15th Amendment does. It doesn't create the right to vote. It protects your right to vote from state encroaching on it. So in that Bradley discussion, he's asking whether we should be looking at whether the amendment creates some affirmative duty. And maybe that's when we make the decision that Congress should be stepping in to protect it. Take a look at pages 9, 10, and 11 for a little bit consideration to some of the things Bradley says. Take a look at this and you should start thinking back, okay, I remember seeing this. But one of the things that Bradley says here, go back to the first line. Bradley says the method of enforcement of the legislation is appropriate to the end, which depends on the character of the right conferred. In other words, how big of a right is the state's taking before I decide whether I'm going to honor it. One method of enforcement may be applicable to the other and not. And so these are the things that Bradley is saying to us, go through, and you should be saying, okay, I remember talking about some of that in my reading of this opinion. So now the ultimate reasoning that this court takes us to is this. Can we use the 13th, 14th, 15th Amendments to help decide this matter? In other words, Cruikshank and these 100 folks who did this thing in Grant Parish, this mysterious bad thing they did that's causing them to be indicted, can we use the 13th, 14th, and 15th to help them? So the court in this reasoning says, well, we told Congress they can come in and help if there is some form of chattel slavery, if there's a badge and incident, but that's not happening in Grant Parish, so they can't use that enforcement power. Well, we told Congress they could come in if there was a violation of due process or equal protection, but that's not happening in Grant Parish. In other words, Louisiana, the state of Louisiana, they're not depriving anybody of that stuff in Grant Parish, so you can't come in under those enforcement acts. And then they said through the 15th Amendment, we told Congress that you have the right to enforce if the state of Louisiana won't allow these folks to vote. But that's not happening in Grant Parish either. So we're not really finding a way to get jurisdiction over this situation in Grant Parish, Louisiana. Why? What is the missing element? What is the missing element? Yes.
Government
One
actor.
second, hold on, sorry.
The missing element is
A government actor.
beautiful. Remember, I said that none of the Constitution ever applies to individuals having to owe duties to individuals. The government has the duty. And so the court in this analysis says what happens in Grant Parish, I didn't see any governmental actor there. I didn't see anybody from the state of Louisiana cloaked with that authority in Grant Parish doing the thing that was done in Grant Parish. And therefore Congress cannot come in under any of those Reconstruction amendments to make the argument somehow that it had power. So then they said, well, there's one last hope. We do have this Ku Klux Klan Act, and that was designed for when we have issues with the Klan. Can we use that? And what's the problem using that Ku Klux Klan Act? What's the problem? What did the court say in its analysis? Where's the problem there? I'm listening.
That it was too broad.
So it is, they said it's vague, and some of this is confusing, and I don't really know who pled what. What did you learn about the warrant requirement? It has to be particularized, right? That was one deficiency with it, that these allegations weren't specific enough. But what else do you remember them saying? There was one second problem besides the particularity, and it was what? What is it that they said under this Klan Act, in order for Congress to have power to come and get you and indict you and charge you, you have to be doing the thing how?
They said that you had to be like disguised or like something.
No.
Right?
No, what is it? What is it? Yes?
1 second.
Mhm.
You have to be intentionally trying to deprive somebody of their federal.
There has to be an intent, not just to deprive you of your federal stuff, but to deprive you because of your race, your color, right? So they said that's not there in Grant Parish. I mean, what happened that day was a bad thing, right? But we don't know that somebody did it because intended to do it to you or intended to harm you because of your race or color. So they said, look, we can't give Congress any power here. They don't have this authority to come down into the state of Louisiana and meddle in something that truly is just a local matter. And so when you read U.S. versus Cruikshank, what you clearly begin to see is that this is a little scuffle. In Grant Parish, these are some local folks having a little bit of a scuffle, right? I mean, it makes logical sense, correct? I mean, you don't just go get the whole federal government every time there's a little scuffle, correct? That's what Cruikshank is saying, that if you're gonna go get the federal government, let it be something like 100 people scuffling and you don't have the police force for that, right? But just 2 or 3 people scuffling, a few, so it seems logical, am I right? So this case ultimately says Congress does not have power to come down into the states when you don't have an individual from the government causing the constitutional deprivation. So one of the things that everybody should have in your outline about Cruikshank is that we get from this conversation the state actor doctrine, right? Making the constitutional applicable when there is a state actor. The other thing we should get in our outline from U.S. versus Cruikshank is that it places tremendous limits now on the exercise of power that Congress is trying to control. So we're limiting power. We're letting Congress know that you came down here once and you fought us with the Civil War and you stop the enterprise called slavery, but you're not doing it anymore. We're not having that anymore. We're gonna put some boundaries in place. The third thing that this case does, everybody go back to Con Law 1 when you learn McCullough versus Maryland. Remember that 1819 case, and remember that gave Congress a lot of discretion. Now this takes McCullough and just reduces it to nothing. The next thing for your outline is that it limits that 14th Amendment to only when there is a identified governmental actor that you can come and say they caused this particular deprivation. But what is the worst thing here is Cruikshank says that the Bill of Rights is not incorporated. And so that First Amendment, that Second Amendment, that 14th Amendment, it's great on paper. It's a protection if the federal officials are depriving you, but if you're on a state level and somebody's taking it away, it doesn't even apply. Is that alarming?
Yes.
Very. And then it says that if you want to prevail here under this Klan Act, you have to be able to show intentional discrimination. So it really places these tremendous limits on the privileges and immunities clause. And so now what I want to know, someone in this room who wants to be a federal prosecutor, I want you to go back to this moment, the day this ruling comes out and you're a federal prosecutor. And you only wanted that job simply because you see a prosecutor as a minister of justice. Remember learning that in professional responsibility? And as that minister of justice, you want to be a protector of people. I want to know, what is U.S. versus Cruikshank going to do to your prosecutorial motivations? Rayvon?
1 second. Are you asking in the federal sense or in the state sense?
The federal sense.
It's gonna decrease your motivation to go after individual state actors.
Which is a conclusion.
Okay, so because they're saying that you can't go, there has to be a state actor. There's no incentive to go into states and go after private actors who are violating federal law.
So I completely agree. So what Rayvon is just saying now is that this one case, U.S. versus Cruikshank, tells us that I don't want to be able to be a federal prosecutor at this hour in time because I don't have any power to do anything under any of the Reconstruction Amendments. I don't have any power to do anything under the Civil Rights Act. So tell me, what does this do now for all the newly emancipated people who had these great hopes of being citizens and being voters? What does this do to them? Yes.
They no longer feel protected anymore. There's nobody who can come down and save them if their states do want to turn on them.
And that's why this conversation is important, because what do you learn in criminal procedure? You learn about habeas relief, right? And what is habeas? It's about going to the federal government for help if the states violate your right. What do you learn in constitutional law about 1983 actions, about the ability to end up in federal court if some state actor violates your rights? And so what we're learning now is that it left these people who had this hope. I mean, this amazing, amazing hope after Reconstruction, it leaves them now less than 10 years later realizing none of those amendments can do anything for me. The federal government can't do anything for me. And what's the odds of any state official doing something for them? None. None. And I want everybody really right now to not just remember, I said to you, as lawyers, you don't read cases. As lawyers, you role play. And you say, that's really not Cruikshank. And that's really not the two anonymous men in the opinion. That's me. That's my brother. That's my uncle. I want to know, what are you feeling that day when you decide now that I'm not in chattel slavery anymore? I'm actually free, but I don't have any federal government protection. I'm free down south. What's your day like from this point forward?
Fear.
I'm scared, which is where I was when I was in chattel slavery. I'm listening.
I was just saying, walking in fear.
I'm always having anxiety, which is where I was when I was in chattel slavery. What am I feeling?
Unprotected, not valued.
I'm completely vulnerable in this foreign land. I have no protection, which is where I was in chattel slavery. Yes?
I'm just trying to stay out of harm's way and really trying to lay low.
I don't even want to be out on the street. I just want my little hole over here, which is how I survived chattel slavery. Yes?
One second.
Probably feel very betrayed.
So I feel played because I was out on the battlefield, you know? When y'all was fighting the Civil War, I didn't just sit down and watch. You know, I got out there too. And I was fighting out there too, trying to help this government reconstruct itself. And you told me as a result of that, that you were going to do right by me. So now I feel very played. I feel betrayed. I don't trust the government anymore. Oh my God, now we sort of see how this stuff is not old anymore, right? So we got that, which is, by the way, how we felt during chattel slavery. What else are we feeling? This is important that you don't do this in abstract. I'm listening.
I feel lost because now if I have children, I'm thinking about their futures. I was promised that they were gonna have a chance. To
Yes.
learn these things, and
Yes.
are not gonna have that chance.
So now I feel hopeless, I feel powerless, I feel consumed now for my children because I don't know if their life is gonna look any better than mine, which, by the way, is how every parent felt during chattel slavery. Yes, and then yes.
However, everyone don't feel that way. I think some people are rebellious towards it and trying to see what they can do to change it.
So there's some people who are inspired by that and said, look, the first system was bad. We got out of it, right? I'm gonna fight this system too. So it inspires some people to fight harder. I love that, which happened in chattel slavery, by the way. And there was somebody up here, all right?
1 second. Right in the hat.
It really just, because they're trying to now become a part, like you talked about the integration into the system, they now have no voice. Like their voice will not reach the halls of Congress because there's no protection from the state assaults every day on their personal rights.
This is so important because now it's not like we're just removed, like when we won a plantation and we didn't have a voice. We don't have a voice because our voice is through the vote, right? Our voice is through political office, our voice is through political life, and we don't have any way to have this society reflect us. So we're marginalized, and I always explain chattel slavery as a system of forced marginalization. And when you think about it, that's all this is again. We are forcing people into a life of marginalization. And so you kind of see that we have really made no progress. Now, what's important for me, as I always say, you know, this moment comes in every lecture. What am I gonna say?
What's not written on the page?
What's not written. Because that's the most important thing always in these cases. It's what is not even captured on the page. What is not captured is more important in most of these cases than what the court will ever report, right? And so I want us to think about this narrative, which is what this case does. It creates a narrative. And the narrative is really just an account of a story that is widely believed. Everybody believes the narrative, it even seems harmless. This narrative here is that we're protecting the folks from the big bad federal government. We're not gonna let the federal government bully us. We're gonna have our own state, our own voice. That's the narrative, and it seems very harmless. The work of effective lawyers is to always go in search of that counter narrative. And that counter narrative is the counter story. It's the story that is often sheltered by that narrative. It is the story that is not heard because the narrative is so compelling that it loses its identity. And so what is valuable about this story is really not the narrative at all. It's the counter narrative. So we go into the real facts. The real facts is in 1865 when chattel slavery's ending. Who ends that? It is the Republican Party. Who are the Confederates? Who are the people who want to maintain slavery? It is the Democrats. So it is a flip of what we know today. Republicans were friends to Black folks. And this day in Grant Parish, what we really have is an election that is a contest between Democrat and Republican. It is a contest between the power of progress in the name of Republican and the power of Confederacy in the name of the Democrats. So where are the Blacks gonna vote? They're gonna vote Republican. So outside that courthouse today, what we really have on that 1873 day is some Black voters who decided that they were gonna exercise political power and they cast votes. And the fear was that if they got the chance to cast their votes, it would change the complexion of this election. And so those Black folks that were inside that courthouse that day saw that that election was being compromised. They saw that we went and did the right thing. We exercised those 15th Amendment rights. We took literal risks. And now somebody's getting ready to just discard our votes and just hijack this election. And they said, we're not gonna have it. And so they're inside that courthouse and they're trying to take a stand in defense of their 15th Amendment right to vote. And Cruikshank and all of the vigilantes outside the courthouse that day decide that they are going to pay for that decision to participate in that election. And so they start releasing bullets. They start firing guns indiscriminately all throughout the town of Colfax, Louisiana. They not only kill Levi Nelson, who goes anonymous in these opinions, Alexandra Tillman, who goes anonymous in these opinions, but they not only brutalized 250 more people at least by bullets, some by lynchings, some people weren't even out voting. They just happened to be Black that day, all of them died. Some of the people were trying to surrender that day. They didn't want to even participate. They give up. I just give up. It ain't worth it, but I killed them too. I killed them to make sure the world understands that when Congress came here and tried to have a civil war and end what they thought was the Confederacy, I need to kill them in public so Congress understands the Confederacy didn't end with the Civil War. So I don't take them behind buildings and kill them. I kill them out in the street. And then after I kill them out in the street, I start killing all the witnesses that might testify because I need Congress to understand that they didn't end the Confederacy. So I'm gonna do this out in the public. I'm not hiding because I need Congress to realize they can't protect you. And so that day in Grant Parish, Louisiana, we have mass loss of life. The opinion doesn't tell us anything like that. They gave us a narrative. I want us to enter that courtroom, if you don't mind, go to that courtroom scene. And this prosecutor, this US attorney who decides that he's gonna take these folks to trial that day, this man actually is gonna have to have witnesses. Who's gonna be the witnesses? Who's gonna be the witnesses? I mean, think about this. So he has witnesses. So some of the witnesses are gonna be some of the local white folks who say this isn't right. Some of the witnesses are gonna be some of the local Black folks who say this isn't right. Do the witnesses risk their lives? Absolutely, absolutely. More importantly, Mr. Beckwith, who is the US attorney, does he risk his life? Absolutely. So this is what lawyers do. While we're telling these stories, everybody should be saying, where would I be in this story? Where would I be in the story? Would I be the lawyer for the police department that would help them get out of these charges? Would I be the lawyer for the US Attorney's Office that would help prosecute folks? Would I be the defense attorney for Cruikshank? Everybody should be dreaming about the role they play. Look at Beckwith. Don't ever forget this name after today. You should see on the monitor, this newspaper article from 1874 says that Beckwith walks into this New Orleans courtroom for trial that day. They said he is graphic in his portrayal of what happens in Colfax, Louisiana. They say he is so poetic that day He is fierce. He has people in that courtroom actually crying. This is the language that you're seeing on the screen. He went out to give a very detailed interpretation of what happened to all the Negroes that day. The Negroes rushed out. They were shot, he tells the jury. He goes on to say that from the moment that they tried to vote, that they had been persecuted in this small town. He goes on to talk about Nelson. He gives Nelson an identity finally. The Supreme Court does not humanize Nelson. We don't even understand that Nelson is somebody's child. We don't understand that Nelson's wife didn't get to hug her husband that night because the Supreme Court doesn't allow us to experience that. But when Beckwith talks to that jury, they feel Nelson's wife's grief. This opinion newspaper editorial says that the court had to recess for an hour after Beckwith spoke to allow the witnesses and the jurors just to recover. This is a white lawyer in 1874. Doing the work of making sure this country has those civil rights protections that we talked about. This Supreme Court knew when they wrote this particular opinion that we had in 1866 a Mechanics Institute riot. And what was that about? Black folks trying to vote here in Louisiana. They didn't mention it. This Supreme Court knew when they wrote this opinion that we had a Bossier Parish massacre in 1868, all over the right to vote. They just did not mention it. This Supreme Court also knew in 1868 we had an Opelousas massacre. In 1868 we had a St. Bernard massacre. 1870 Donaldsonville massacre. Colfax, Coshado, 1873. All of these murders over one thing, Black folks trying to vote. And with every one of these massacres, there was no federal government help. It was impunity. Absolutely no accountability for anyone, which tells us how big of a man Beckwith was to come down to Louisiana and even attempt what he attempted on that day. So I want us to now see the true story, if you don't mind going to the slides, the part that the court failed to tell us about. Everybody take a look at this, because this now fast forward is today's setting for this story. And when I say today, I mean in the 2000s. The sign Grant Parish in the town of Colfax, you will see when you enter Colfax, Louisiana. Go to the next slide. That's the sign. And notice that this sign is sitting outside of this courthouse that we're speaking about today. And so this court case does not mention to us that after this happened, the vigilantes, Cruikshank and the other 100 folks, decided that it was not enough to slaughter all of these Black folks in the town of Colfax. They erected a sign, what you're looking at, and that sign has language saying this sort of teaches you how it works down here in the South when you try to vote. I'm paraphrasing, of course, but that sign was not erected in 1874. It didn't even go up in 1880. The sign was years later to still celebrate this happening, and it remained outside into the 2020s. Go to the next one. This man is very important. You know the name Avery Hamilton. He is one of the descendants of the victims of US versus Cruikshank. Some of the Black folks who were slaughtered in town, he is alive and remains in Grant Parish, Louisiana. Next slide. This is Dean Woods, who is one of the descendants of the vigilantes, the people who caused the murder that day. But they have done something pretty remarkable. They've united over this history, and they are regretful of this history, and they realize that this history has been suppressed to the detriment of a nation. And so they have gone on a venture to try to correct this history. So if you go to the next one, that's actually a scene from this massacre. The way it would have looked that day in that town as bodies were being picked up and hauled off. and taken for burial. Go to the next one. And finally, Dean Woods said this sign has to go. And so that is his efforts to get the state of Louisiana to remove the sign celebrating this massacre. Go to the next one. And you can see closely what it says here is on this site occurred the Colfax riot, in which 3 white men and 150 Negroes were slain. This event on April the 13th, 1873 marks the end of carpetbag misrule in the South. And that was up until I think 2023. Go to the next one. And so there is the vacant spot now where it has been removed from. Go to the next one. And that is the memorial to the vigilantes, which still stands around the courthouse celebrating the great work they did that day in suppressing the Black vote. Go to the next one. This is April 13, 2023. And that is a moment where now the governor and the state of Louisiana and some of my law and racism students, has anybody in here worked on this project? Rayvon did. So it was a team of us joined forces with these 2 descendants to see if we could help them raise the funds that they needed so that if you ever go into Grant Parish, the names of all of these people that lost their lives would no longer be anonymous. They would have a place in history. So if you go, that is the day the ceremony happens, where this monument is finally unveiled. Go to the next one. And you can see how well attended it is. There's folks from all over the state there that day to see this unveiling. Go on to the next one. Behind me, the man, you all tell I'm a rookie with the camera, but I couldn't miss this moment because it was the same time of year as this, April, and I told my students they couldn't come, y'all have exams, but I said, I'm gonna document everything and send it. So guess who that is behind me? These are the Colfaxes.
The what?
I'm sorry, the Cruikshanks. The Cruikshanks.
Oh.
So these are actual, the guy on the left and the guy in the middle, they're brothers. And they learned about this history. They actually live in California. Their last name is Cruikshank. And they learned this history and wanted to be physically in the state of Louisiana to witness it be corrected. So they came from California that day just to witness this whole story be corrected to the extent that it could be. And they told me, I said, I need a picture for my law students. And they said they have a granddaughter who is in law school in California. So I said, you tell your granddaughter that Southern University teaches US versus Cruikshank faithfully. And I want to know if her California law school does. So they text her and asked her, and she said no. So I want you all to understand this, because this case, in my opinion, it not only is Louisiana history, but this should be a part of every history book and every con law book in the country. But what is the case that is always cited for this story? What case do you learn in con law 1 that tells you that there's the state actor doctrine, and if the state is not violating your civil rights, you don't have a cause of action? What case is it? Because there's another case that represents the same proposition that you learn about. Which is it? Do you remember the civil rights cases? Yes, it's the same thing, but they don't cite this, they cite the civil rights cases. But go to the next one. And so you see Mr. Thomas, he worked on this project with us as well, and that's one of the descendants in the middle. Behind us is the new monument that was just unveiled like a second before we took the picture. Go on to the next one. That is Dean, the other descendant, the monument behind us, but go up. I want them to see the monument. Go up one more. Up, the other way.
Sorry.
Yeah, there. That monument is the first time the world now sees the names of every person that lost their lives in this Colfax massacre that day. Next one. And I have a friend who is on the board for the Civil Rights Museum. And so I was telling her about the unveiling, and she said, I've never heard of this. So I said, well, why don't you try to get this in the Civil Rights Museum? So if you look at the next slide, just as amazing how knowing people helps. You all know those guys on the front row, I'm sure, right? Look past them, go behind them. Do you see those 2 familiar faces? They were able to come and be honored at the unveiling of Louisiana Civil Rights Museum. So the hope is to get this story now brought into Louisiana Civil Rights Museum. And so I wanted you to see now, this is really the true story of what happened in US versus Cruikshank. I want to know, how do you all feel about the deception? About the suppression of the story? How do y'all feel? Yes?
1 second.
Mhm. And then I see a hand in the back. First front row up here.
Your hat.
I feel that, although, the US federal government was the victorious one in the Civil War, the Confederacy is letting us know that despite y'all winning the war, we're winning the battles here and now. We're going to continue doing what we want to continue to proliferate this dissension and this hatred, and there's nothing really you can do about it.
This is an important point because what he's saying is that history just records this fact of the federal government winning and the South losing. But if you look at every measure of success, his argument is that the South really never lost at all. And in fact, just in case you don't know this, those monuments that are being put out outside of courthouses that celebrate the Confederacy, those monuments went up way after the Civil War. They were in the 1900s that they were being erected. So the Civil War was long over. That was a physical statement to make it very clear that it is the 1900s and we're still present and we haven't left. That is a very, very important point to understand out of this, because if that sentiment still exists and we have a Congress that writes legislation believing that it can do some good, we understand today that legislation cannot change conditions for people. There's a limit to what legislation can accomplish, and we're seeing the limits of that today. I saw somebody in the back. Yes.
Like you said, how do you feel about the deception? I feel like it still happens. It's terrible to say it angers me, because it does anger me, but it still goes on in 2024. We're always being deceived. The facts are always not being told. The full story is never being told until somebody else wants to say it, and then they get slapped back down. It still happens today. It's just sad that it still happens, but it's America at this point.
So the lesson now is that you're always on a mission for the counter narrative, and you never, when you hear the narrative, accept that. Anybody else have any reactions to this, what you read and what you heard and what you thought about today? I'm listening. Yes, I see 2 hands.
1 second.
Even reading it and not remembering the background to the case, I could tell there were hints, like it was way too vague, and they slipped in the word murder. It was never mentioned again.
Yes.
And it just felt, I was just filled with disgust, just hearing the full story and hearing how they completely blanked out what actually happened.
So what she said is that, this was great persuasive writing. Don't leave, sir, because right next to her, she said it's great persuasive writing because they told a narrative that fit right into the analysis that they wanted to give us, right? But in the end, the analysis said this had nothing to do with the Reconstruction Amendments, and it went right to the heart of the Reconstruction Amendments, correct? So you can see how a good persuasive writer can write any story that fits, the ending and the middle can fit together, and that's what they did. And you start to realize that I have to read now with a much more critical eye. Her and then the gentleman next to her.
Just looking at like the monument in front of her house still being there till this day. And I don't know exactly where the new monument you guys put up, like where it's located. Like, I just feel like that should have been taken down as well, because although they took down the sign, that monument, it still shows like that celebration of that.
Yes.
It reminds those people in that city, like, we still have that power.
So what she says, this is also important, and there's a word that I want you to think about. It's called memorialization. And I do a lot of work under transitional justice, but that's a pillar of transitional justice. And what memorialization reminds us of is sometimes what we take down is really necessary to make a statement of who we are as a people, but you cannot overlook what you leave up. And so what she's saying is that when you took that old original sign down that celebrated the slaughter of these people, but then you left up the other taller sign, the big cement monument it still memorializes that there's some sentiment in that community that this was okay. And that is not accomplishing anything is the point. Next to her, and then on the end over here.
I've seen it as more than just being deceptive of them, because it's like you wrote it in a way to say basically like the federal government doesn't have nothing to do with this, when in actuality it does completely, but it almost makes it seem like the federal government was trying to cover up their true beliefs of like, we don't care that this has actually happened, we just gonna write it and go about it everywhere and say that it doesn't pertain to us. So it's like they found every obstacle they could to say it doesn't pertain to them, just so they wouldn't have to take some type of action. So it almost gives a sense of like, that is what you wanted in the end, and you didn't really want the blacks or whatever to actually have that vote, because it's a group of people. You're saying it was no state actor, but you also have the state who's not acting, this huge group of people who just committed this big crime against this race of people by trying to enforce what the federal government gave them. So it's like it all makes a big loop. It's like,
And this is a very important point to hear this. You know, after the Civil War, you think like people who actually took up arms to fight the government, you would think like they would be ashamed and they would go into hiding and they might be embarrassed, but that is not what happened. The folks who were on the Confederacy side, once they lost the Civil War, supposedly lost, they just took off that uniform and put on another uniform. And so some of those folks became great medical doctors. Some of those folks became governors. Some of those folks became legislators. The point is they ended up in Washington, D.C. And so this Supreme Court, some of them became Supreme Court justices. And so they were influencing not just law, but policy. And that is very important. One editorial I wrote, this guy says after the Confederacy, when he comes out of his house, people reacted to him like he was Prince. You know, like it was like, I'm a rock star. Like that was the way they were celebrated. So they basically went into other forms of government and just started shaping law and policy there. And one of the best examples that I can give you of that is after chattel slavery ended, of course, we don't have the free labor in the state anymore. And so we have all these plantations, they've all been destroyed by the Civil War. So somebody needs to build them back up, number one, but then somebody needs to get the flowers and the plants growing and the crops, right? So who's gonna do that? I mean, who's gonna do that stuff? Because it used to be the enslaved folks, right? But they're not slaves anymore. So we get this guy named Samuel James. Major Samuel James is his name. He was a very high-ranking Confederate general. He now has on his lobbyist uniform. After the Confederacy is over, he goes into the legislature and he says, listen, we got all these crops out here and somebody needs to fix them and grow stuff. I got a great idea. You know, all these black people, they don't have no jobs. And so if they don't have no jobs, they just lingering around. Why don't we give that a name? Vagrancy, that's it, vagrancy. And vagrancy, if it's a crime now, it has to have a sentence, right? So all those black folks that's out here, we're gonna give them vagrancy charges, we're gonna sentence them. And then when they're sentenced, the state says, well, we don't have a prison. Well, we got a problem because we don't have no prison. Why we don't have a prison? Because we used to deal with them on the plantations. So he said, well, I got a solution to that too. Why don't I just start leasing my plantations? Because I got all this space over there. Well, that's a great idea, Samuel James. So he gets a lease. And we now know it's called convict leasing. And he begins the idea of all these vagrants now, we'll lease them out, and all the plantations that were destroyed, they go right back to work. He owned about 8 plantations, but the one that you all know is called the plantation of Angola. And so this is the story of Angola, but the point that he makes here about these Confederates and how they went on to shape law and policy. So then before you know it, when you start reading down south, the census is saying they got a crime problem down there in Louisiana. Boy, those people are so bad. Boy, they should have just kept them on the plantations. But it's like nobody makes the connection that, oh, that happened by design. So that is how these Confederates left and went into governmental spaces. Now, final point, I know y'all ready to go. Can you go to the next slide? Because I don't want anybody to leave here saying, well, why did we just come here on a Friday for this stuff? I just want you to see here. This is the ruling from March 2024 involving Donald Trump and the Colorado voters saying we don't want him on our ballot. And guess what law they use? The Enforcement Act, the very one that we're studying here. And guess what the fight was about? The people of Colorado saying that the 14th Amendment has some language saying who's qualified to be an elector. And they also said there's an enforcement provision y'all need to enforce. And if y'all are not gonna enforce federal government, we'll just enforce here in Colorado. And the federal government said, hold on, you can't just come and start using our enforcement power, that's ours. So you see the flip here, and this is 2024 March. I just wanted you to see that. The other thing I wanted you to see is once we left the Brave Cave and we sat around figuring out, well, what do you do about something like this? If the state is aware of it, the state is not gonna do anything, what are you gonna do? What do you do? I mean, you have to go to the federal government, correct? So you can still see this need to have a relationship with the federal government and the need to be able to depend on them for oversight. So I wanted us to understand that what looked like a very dated conversation is extremely timely. It's very, very important that as you think through all of the con law lessons, you're constantly thinking about if the state takes this right. We just studied speech in Con Law 1, First Amendment. They charge you with criminal anarchy, right? That's your free trial. What do you do once you get locked up? You go into the federal government under habeas. Hey, they just took my constitutional right. Do you sort of see the relationship and why that's important? So that's what I wanted us to be able to understand. This understanding of the tension, it continues to cause whenever you have the state having to have a federal government say we're here because we're a union and we want to make sure that as a union we're united and you're not following the rules, it's always going to cause tension. And so I wanted us to see that. Any final comments, thoughts? Things you're inspired to do as a result of this? None of that? Yes? All right.
I guess it's like you said, to always look for the counter narrative. It's like reading the case, you would never know the extent of how much it was, I guess, like covered up, I guess, you know, is the lack of the better word. So you always gotta look what's not being said, you know.
And why do y'all think this was suppressed? I mean, why do you think this is not in every constitutional law book? Because it's a very important case about federalism, right? Important case about voting rights. Why is it not there? Why is this suppressed? I mean, why do y'all think this is not everywhere? In every book you read, why? What's the value? I'm listening. Mm-hmm.
I think it's suppressed because they don't want the masses of people in the country to know more about this massacre. There were over 150 Black people killed, over white citizens, and they don't want uproar to happen today because of what happened in history as more people get educated about.
So what he says is there's a potential that if the world started knowing about the Colfax massacre and they knew about the other 13 massacres that I mentioned, that they may uproar as in, oh, I'm mad about the loss of Black life. Is that true? Is that the only thing that would happen? Yes. I think there's another reason here.
I would say they don't want I would say they don't want everybody to see that history is repeating itself.
Is that all? I'm hearing a bunch of G-rated stuff from lawyers. I'm looking for a real lawyer who has serious analytical skills, who can see what is not said. I just mentioned about 15 massacres, mass loss of life, domestic terrorism, and nobody in the world knows this history. And so, y'all telling me G-rated stuff. I'm listening.
The narrative that's being shared, that's the narrative that they want known. Nobody wants to say the federal government doesn't have control, because it looks like a loss or a lack of control over really serious situations.
Yes.
The state can't control it, the federal government can't control it. So showing that the union won, saying that narrative the union won, but the actions are that did not happen. They had to continue the narrative somewhere in this.
I agree, but there's something way more sinister. I'm listening, front row. Y'all have to start thinking like lawyers right now. Lawyers see what nobody else sees. And then there's a lady over here after the front row. There's a reason that this is suppressed, and there's a danger to the suppression. I want to know what it is.
I was just gonna say that I think it's the lack of accountability for the individuals that took part in this deprivation and in the killing of these people. and, you know, the institutions that allowed for it, it's giving them the license and opening the floodgates for them to never answer for these heinous acts.
So what I'm hearing is that we have not held people accountable in any of these massacres. And these were massacres that no one could justify, right? The violence, the level of violence. So maybe that's something to do with it. I see the lady in a black jacket and then the gentleman in a white shirt.
I was gonna say the same word, accountability. The reason why the law was created was to create solutions for problems. And so there's a problem that these people have suffered from and they have never been provided a solution. And so it's as if to say, okay, the law does not, you don't qualify to be afforded a solution for this problem. And
Which is chattel slavery all over again.
right.
No legal protection.
And it's pretty much the reason why, you know, things like critical race theory are coming under so much scrutiny, because it's basically the truth, not the full truth not being told, and people are escaping accountability for that.
So I'm hearing some things, the gentleman in a white shirt and then the lady here with her hand up and then another one, got 3 hands. I still haven't heard it.
I have 2 points to it. One of them being that if you do the work of the government, the underlying work of the government that they can't do like in their own spaces, you won't be held accountable and you're gonna be let off of it. And
Yes.
it's also in a way, it's like, they just like you, if you do what the government wants to do without them having to do it, we're not gonna prosecute you for it. So it's basically like y'all carry out what we actually want to do and enforce, show the power, and we won't do nothing to you. And it also would show that if you actually do it, like a group of people come together and just keep on doing it, that it's gonna make some type of change. Like, because in this case, all those black people died, they didn't want to vote and the government didn't do it, didn't want to do anything about it. If you were to do something similar in that situation today, would the government do something about it, or would they, like she said, just not have any control and the people would win over the government?
And so there's a lot of cases here that he's speaking of, which is that when you create a space in law for people to bypass these protections, what you really do is encourage people to practice self-help. So if they go and do it, the government doesn't have to discriminate, right? Because the community is discriminated for us, so we're protected because we've circumvented the governmental obligation. I saw another hand here, yes.
I got a lot to say that kind of goes with all that from what everybody says. But the first point from the young lady about laws like being made to give people a grievance, I don't agree that that's why laws are made. I believe that laws are made to keep people in boxes and to enforce the agenda. And all today we've been talking about the idea of states' rights, federal government, and those different things, but we're overlooking the whole idea of white supremacy. That's what it's made for. So we're saying that we want to make sure that the federal government has their rights and they're not encroaching on state rights. It's really that we want to make sure that the minority that believes in white supremacy continues to reign. And that's the idea of the perception thing, because your perception is your reality. So if we hide these ideas and we make it seem like it's one thing, everyone will believe that. And even when they don't, we have so much political power that we can simply just ignore them. Because like you said, those in the federal government is controlled by those from the states. So if the states believe these things, even when they go in the federal government and we have this idea that the federal government can protect us, the federal government are the people from those states. So if the people in our states want white supremacy to continue, they want to continue to hide these things from us, there isn't really a grievance. So then that makes me think, well, how far can I really get? Because I really can only get as far as you will let me get. Because even in Colfax, like we know about it now, and they got the sign to go down, but yet the monument is still there. And even outside of that, I bet you if we go to Colfax, Louisiana, in that area, there's still racist laws on the books right now. So how far can you really go? What can you really do when the entire United States was built off of you and to benefit from you? Because they didn't end slavery because they felt like, oh, humans, like we need to give them rights. They ended it because it wasn't beneficial for the entire union financially, economically. It was never about human rights. So how do you continue to petition to a government that was never even made to serve you in the first place?
Very, very interesting point. And it also makes us now realize the importance of the international space that I was talking about, for that very reason, because the goal should have always been human rights. And I don't know if you all know that, but when I taught civil rights, that was a point that I would always make with the class. W.E.B. Du Bois thought that our measure of equality was gonna be through the achievement of human rights. He opposed a civil rights agenda because civil rights does not protect your political rights. It only gives you so many freedoms as his thoughts. And the United Nations, when it was first formed, was able to say that if he comes in the room talking about this kind of stuff and it's gonna embarrass us with Russia sitting at the table and all these new entities around this new thing called the United Nations, they sort of got to the head of the NAACP and got him out the room so that we could now just limit this to a civil rights conversation. And then we could clearly violate your political rights because all you really wanted was civil rights. So there's this argument that really we should have always been looking as a people for something broader at the point of Reconstruction. And so the Reconstruction era was designed in a way that was way too limited. And so you raise a point that's worth considering now, that is it time now for system change? This entire system that has allowed this to live, is it time for that to change? I see a hand here and then one in the back. I still haven't heard, by the way, the reason that this is being suppressed.
I think the point that we're overlooking is how we have to go back that there's just multiple massacres that occurred. So these massacres are being suppressed today because it would be synonymous with the genocide that is going on across the globe. And in America, this is legalized genocide because it's still going on today. These things are being suppressed just to hide the fact that it's always been going on in the tradition. Like it's deeply rooted in American history.
Wow, did y'all hear that analysis? That con law language, all right, it's deeply rooted in history and tradition, so we can go out and kill folks, and that's our history. But what he's saying now, this is the important point. If the world, if every book, every news station, every magazine told us about the mass number of lives that have been lost in this country for people engaging in lawful acts, would we have a different understanding of violence? Would we see violence through a very different lens? It would not look to us like that black male with the dreadlocks that we see on the news every evening, because that's what we associate with violence. But if we thought by any chance that there were people walking around us who had never been held accountable for killing someone, somebody who has lynched somebody who's never been held accountable, somebody who's killed 500 people in their lifetimes, there's never been accountability, we would begin to see that group violence, domestic terrorism has been normalized in certain communities. And we would not be seeing people as honorable and noble and law-abiding and the standard of excellence, because we would see them in their flawed self, the way we see everybody in their flawed self. So there's some value to promoting this narrative that there were just two people and it was just a little scuffle. That they just had a bad day. You know, it wasn't domestic terrorism. There's something different about telling that story. I'm listening on the back row.
So I was just,
Second, please.
okay, so to the point what she said, be an educator of 18 years, I also think the suppression is to prevent the rewriting of history and to continue the ignorance of history, because there's been many efforts to remove that from our history books, also in the educational world. And so that ensures that the continuation of ignorance also continues and enables the white supremacy that a lot of people don't learn about as they also come through school as well.
So I agree with that. And I also want to mention this in case you don't know, but there's a group called the Daughters of Confederacy. And they are the daughters of the Confederacy, and they have a big influence in what goes into history books. And their version of history has always been this lost cause, that we won kind of thing, and we were honorable and we stood up for the state and we did what was right. And so they influence a lot of what goes into history books. And there's a movement, of course, to have them be on boards that decide the history curriculum. And so getting things into history books, sometimes it's not that the writer is ignorant, it's very intentional that the history be suppressed. I see two hands over here, one in the back and one on, over here.
To piggyback off of what she said about the laws that they do create and the meaning behind them, I feel like that made a great point on what literally just happened in Louisiana with the laws that they just passed with the extension of the no parole law.
Yes.
So they did that law, making jail sentences longer, but they also did the concealed carry law.
Yes.
You wouldn't have to have a permit. And I think people overlook the fact that those two go hand in hand. Because
Yes.
if you have more concealed carry, I'm thinking of it in the sense of they know that a lot of African Americans carry guns, and they know that the gun violence among them is more. So if you make it to where you can conceal your weapon, you can get your weapon more places now. You
Yes.
can have more gun violence, and now
Yes.
all of these people are going to be sent to jail for longer sentences without the opportunity for parole.
Absolutely.
Now, the percentages of Black people, majority, that's because I'm pretty sure that's what it was primarily targeted against. Not a percentage of those in the jail, and the sentence is going to be longer, and they're not even going to have the option to parole.
And it's gonna be due to the gun violence, and then also simultaneously with those legal changes, we don't fund any mental health issues. And so if you have a mental health issue that causes you to be impulsive, that causes you not to really slow down and think things through, you can see how easily you might wind up grabbing the gun. And I agree, it's very intentional.